Counselor, in your introduction, you appeared to be applying strict scrutiny. One of the factors you said is the state has not pointed to a study that shows that talk therapy is harmful. I don't believe strict scrutiny always requires a study. I mean, look, I'll give you a hypothetical. A state tells dietitians, don't encourage anorexic patients to engage in more restricted eating. All right? I don't think the state has to provide a study to show that that advice is not sound. Do you agree?
Justice Sotomayor, I think that might be true, but that's because that kind of hypothetical is very different than what we have here.
So explain the difference.
In that hypothetical, the counselor or dietitian is telling the client to do something that directly harms their body. In this case, Ms. Chiles is trying to help gender dysphoric kids avoid.
That begs the question, because there are studies that say that this advice does harm the people emotionally and physically. But putting that aside, you agree then that you don't always need a study. An absolute statement like that misstates the law.
No, what I agree is that if what the state is getting at is a statement by a professional that's telling someone to harm their body, that's a different category. But if we're in a situation like this, where there is debated science, where the counselor is trying to help the child achieve their goals, then absolutely the standard this court set in Brown would apply, which requires a showing of causation.
So there's only one circuit that has applied strict scrutiny to this kind of thought therapy. It's the 11th. The others, the 9th and the 3rd, have not. You seem to be encouraging us to apply strict scrutiny here. And the question I have, we're not a court of first review on this issue. Why don't we send it back? I'm assuming that the 3rd and the 9th didn't apply strict scrutiny because they thought they'd have a problem with applying it to this law. Why should we be breaking our normal pattern in this case?
Because there is ongoing harm every day. Ms. Chiles is being silenced, and the kids and families who want her help are unable to access it. It's very similar to what this court did last term in the Mahmoud case, where the 2 lower courts had decided the case on rational basis review, and when this court decided that strict scrutiny was the proper analysis.
Remember, I dissented.
I do remember that, Justice Sotomayor.